Let's take a look at delegating to private agencies. Increasingly, both federal and state governments are delegating judicial and lawmaking authority to private organizations, transforming these organizations into quasi-governmental bodies. The Supreme Court has been suspicious of delegating governmental authority to private parties for a long time. The court has upheld delegations of rulemaking authority to private parties when minimal oversight by federal agencies was mandated by Congress. In these states, delegations to provide private parties are becoming increasingly common. Delegations to insurance companies to regulate workers' compensation and licensing programs are examples. The reasons to privatize are many. Governments often privatize because they lack the expertise to perform the necessary function. Some advocate privatization because it reduces the size of government. Finally, privatization makes sense when a transient or emergent need presents itself and a government lacks the resources to respond adequately. Some commentators have challenged the notion that privatization is more efficient. Others contend that privatization of public functions threatens the public good. They point out that efficiency was not the foremost on the minds of the framers of our nation when they designed our governmental architecture. On the contrary, they were aware that the system they created was inefficient. However, the framers did not foresee the myriad of services that governments would provide. To the framers, governmental functions were policing, corrections, roads, armed services, foreign affairs, and to a limited extent, education. Today, largely as a result of the expansion of government that occurred in the 1930s, federal and local governments directly provide for citizens' health care, social security and pensions, disability, and recreation needs. Privatization gives rise to many legal issues. Compliance with civil service, regulatory, environmental, and constitutional laws, for example, must be considered. The privatization of public functions is popular today, and accordingly, this issue will likely be the subject of much litigation in the first decades of the 2000s. Although the existing law is sparse, a few principles can be deduced. First, there are core governmental functions that cannot be delegated to private parties. Second, courts are more protective of their own authority than they are of legislative authority. That is, a delegation of quasi-legislative authority to a private agency is more likely to be permitted than a delegation of quasi-judicial authority. Third, private agencies that perform governmental functions may be treated as government agencies by the courts. Fourth, the private agency receiving the delegation must be in a position to serve the public interest. Delegations to parties that have only a financial interest are suspect. Finally, all the limitations on delegations to government agencies also apply to delegations to private parties.